There's a storm brewing in the courtroom, and this time it's 9 justices, 0 dissents. We're talking about a 9-0 decision straight out of the Supreme Court. And while it didn't hit the Second Amendment head-on, the words those justices used just cracked the armor wide open. This ruling is already being locked and loaded by gun rights attorneys across the country, and it's got states like California in a legal chokehold. Because when the highest court in the land says that rifles like the AR-15 are commonly owned and used lawfully, that's not opinion. That's constitutional artillery. Today, we're going to break down exactly what this 9-0 decision means, how it's being weaponized to challenge so-called assault weapon bans, and why this might be the beginning of the end for unconstitutional gun laws in anti-gun states. Smith and Wesson versus Mexico ruling. Now here's the part no one saw coming. The most powerful legal weapon in the gun rights fight right now didn't come from a Second Amendment case. It came from Smith and Wesson versus Mexico. Yeah, you heard that right. This was a case about whether gun manufacturers could be sued under Mexican law for crimes committed in Mexico, using American-made firearms. The Supreme Court looked at it and delivered a 9-0 decision. But here's where it gets wild. Even though this ruling wasn't directly about gun ownership, the court's opinion dropped something huge. They stated, in plain language, that firearms like the AR-15 are widely legal and commonly owned by law-abiding citizens for lawful purposes. Now, that might sound like just a side note, but in legal terms, that's a tactical nuke. Because, under District of Columbia versus Heller, and reinforced in New York State Rifle and Pistol Association versus Bruin, any firearm that's in common use for lawful purposes is protected by the Second Amendment. So when the Supreme Court, in a totally unrelated case, goes out of its way to reaffirm that point, and does it with 9 justices, 0 dissents, you better believe that language carries weight. This wasn't 5-4. This wasn't split. This was 9-0. And gun rights attorneys across the country? They're now loading that language straight into their legal briefs, like it's 556 in a mag. California's assault weapon ban. Let's break down how California built one of the most ridiculous gun laws in the country, and why it matters to every gun owner across America. See, California didn't go after rifles based on how they function. They went after how they look. Under state law, if your semi-automatic rifle has a pistol grip, a flash suppressor, a telescoping stock, a vertical foregrip, or even a grenade launcher mount, congrats. It's now classified as an assault weapon. Yeah, you heard that right. Not because of its caliber, not because of its rate of fire, but because of the furniture hanging off it. 2 rifles can be mechanically identical. Same operating system, same magazine, same bullet. But if one has a collapsible stock and the other doesn't, only one of them is legal in California. That's not public safety. That's political theater. And let me tell you, as someone who's spent years inside gun ranges and taught folks how to handle rifles safely, this law does nothing to stop criminals. It just traps law-abiding citizens. A Marine veteran comes home, buys a legal AR-style rifle with a vertical grip to help manage recoil, and suddenly he's breaking the law, not because of what the gun does, but because of how it looks. That's absurd. Even worse, the list of assault features is constantly changing. You might be legal one year, then illegal the next, based on whatever new cosmetic part some politician decides is scary. This is harassment by design. And if you think this only affects California, think again. Because states like New York, New Jersey, Illinois, they're copying this blueprint. It's a nationwide strategy to ban common rifles, one attachment at a time. And I'll say this plain, If a law turns millions of responsible gun owners into potential felons overnight, not based on action, but based on attachments, then that law was never about safety. It was always about control. Legal strategy and common use. Here's where the legal fight hits center mass. Because this isn't just about rifles, it's about one principle: clear, simple, and backed by the Supreme Court. The government can't ban firearms that are in common use for lawful purposes. That's the line in the sand. It was drawn in District of Columbia versus Heller, reaffirmed in New York State Rifle and Pistol Association versus Bruin, and now echoed, loud and clear, in Smith and Wesson versus Mexico. In all three cases, the Supreme Court made one thing crystal: if a firearm is widely owned by law-abiding Americans and used for lawful reasons like home defense or training, you don't get to ban it. Period. That doctrine is now the core weapon in the fight against California's assault weapon ban. Gun rights attorneys aren't nitpicking loopholes. They're firing straight through the center of this thing. They're saying, you call it an assault weapon. We call it a rifle that's in millions of homes, used by everyday Americans for lawful, peaceful, protected purposes. And the law is on their side. Because common use isn't just a throwaway phrase, it's the legal firewall that keeps anti-gun states from erasing the Second Amendment one accessory at a time. I'll tell you this from personal experience. The average guy walking into a gun store in Oklahoma or Florida or Indiana, he's not buying full autos or SOCOM gear. He's buying a standard AR or AK platform because it's reliable, modular, and legal. If millions of those rifles are already in circulation, used by cops, veterans, sport shooters, moms, dads, ranchers, and first-time buyers, then calling them unusual or dangerous is just dishonest. It's legal gaslighting. The courts have already set the rule. And now, with Smith and Wesson, they've said it again, unanimously. So the strategy is simple. Use the court's own words, cite their own rulings, and push every bad law up against the wall of common use until there's nowhere left for it to hide. Miller versus Bonta. Now here's where that 9-0 ruling turns into real firepower. The plaintiffs in Miller versus Bonta just loaded it up, and they're aiming it straight at California's so-called assault weapon ban. In their latest filings, gun rights attorneys didn't dance around. They went straight to the heart of it. They pointed to the Supreme Court's exact words from Smith and Wesson, arguing that if AR-15s are commonly owned and used lawfully, then California's ban is flat-out unconstitutional. Simple as that. Let's break it down. Miller versus Bonta is the lawsuit challenging California's definition of an assault weapon. And California's standard? It's not based on how a rifle functions. It's based on how it looks. Got a pistol grip? Flash hider? Adjustable stock? Boom! Illegal. Even if it's a semi-automatic rifle functionally identical to a compliant one, they'll ban it over cosmetics. That's what makes this case so critical. Because the plaintiffs aren't arguing in circles. They're citing Supreme Court precedent, point blank. They're saying, look, under Heller, Bruin, and now Smith and Wesson, firearms that are commonly owned for lawful purposes are protected. End of story. And with millions of AR-style rifles in circulation used every day for home defense, training, and sport shooting, there's no honest argument left. These rifles aren't dangerous and unusual. They're mainstream America. That's the legal trigger here. Because the Second Amendment doesn't just protect flintlocks and muskets. It protects the tools people actually use today. And if the Supreme Court says so, unanimously, you can bet the lower courts won't be able to ignore that forever. Ninth Circuit resistance. You'd think that after Heller, Bruin, and now a 9-0 ruling in Smith and Wesson, the lower courts would finally get the message. But not in the Ninth Circuit. During oral arguments in Miller versus Bonta, it became crystal clear. Some judges on that panel weren't just ignoring precedent. They were actively resisting it. One judge called the AR-15 a machine gun. Another one called it an A-15, which doesn't even exist. That's not a legal opinion. That's ignorance with a robe on. And it didn't stop there. They questioned whether these rifles are even commonly owned in California, as if constitutional rights magically disappear based on your zip code. Think about that. Would the First Amendment only apply in Texas, but not in San Francisco? Of course not. That logic's a joke, and legally bankrupt. But this isn't just bad reasoning. It's strategic obstruction. Instead of ruling, the Ninth Circuit has a habit of stalling, holding cases in limbo while waiting for something else to move. That's what happened with Duncan versus Bonta, and now it's the same game in Miller. Delay, confuse, deny. They'll call Supreme Court language dicta. They'll pretend stats don't matter. Anything to avoid saying the truth. The ban doesn't hold up under the Constitution. But here's the thing. The clock's ticking. The more the Ninth Circuit stalls, the more obvious the game becomes, and the stronger the case gets for a full-on Supreme Court smackdown. What we're seeing right now isn't just a legal battle, it's a full-blown constitutional reckoning. When the Supreme Court drops a 9-0 decision that reinforces the right to own commonly used firearms, that's not just legal theory. That's a message. And states like California, they're hearing it, whether they like it or not. The fight over assault weapon bans is just heating up. And with rulings like Smith and Wesson backing us, the momentum's shifting. But here's the thing. These bad laws don't fall unless we stay engaged. We speak up, we push back, and we hold the courts accountable to the Constitution. So, what do you think? Is this the turning point we've been waiting for? Drop your thoughts in the comments below. Hit like if you found this breakdown helpful, subscribe if you believe in real Second Amendment coverage, and don't forget to ring that bell so you never miss a fight. This is Firearms Zone, and we don't just talk guns. We defend freedom.